Welcome back to the deep dive. Today we're getting into the really messy part of contracts. What happens when someone doesn't follow the rules perfectly? We're talking about the idea of forgiveness.
It's a huge question. Say one party technically breaches a term. Maybe a delivery is a day late or they use the wrong brand of paint. Can the other side just forgive that? Can they legally waive the breach without a whole new contract or new money changing hands?
Exactly. And this isn't just some academic puzzle. It's about preventing really harsh outcomes. So our mission today is to show you exactly how courts analyze that kind of forgiveness, especially when it's used to stop an unfair financial penalty, a forfeiture on work that's already been done and accepted.
And to do that, we have to draw a really sharp line in the sand. We need to separate two key ideas. A condition precedent, which is, an event that has to happen to trigger a duty.
Right.
From the actual consideration, which is the core thing being exchanged in the contract. Courts treat waiving those two things very, very differently.
And the legal tool we're going to use to pry this apart is called express waiver.
Yes. We need to know what it is, what its elements are, and most importantly, how courts use it specifically to prevent an unjust forfeiture.
Okay, let's jump right in with the classic case that really builds this whole framework, Clark v. West. The stakes here were pretty high for illegal rater's pay, so let's analyze it. First, what are the legally dispositive facts?
Okay, so the plaintiff, Mr. Clark, he's a legal scholar. He gets a contract to write a series of law books for the defendant, West Publishing. The pay structure is tiered. Clark gets $2 per page right away.
Simple enough.
But there's this huge bonus, an additional $4 per page, for a total of $6. But it all hangs on one very specific and kind of personal rule. Clark has to maintain total abstinence from intoxicating liquors for the entire time he's writing.
A sobriety clause.
Yeah.
In a book deal.
Wow. Okay, so what happened? Did he stick to it? Well, no. Clark admits that while he was writing the first book, he did not totally abstain. But, and this is key, he finished the manuscript. West accepted it, they published it, and they started selling it. Clark then sued, saying, hey, you owe me the full $6 a page because you knew I was drinking, and you basically waived the condition.
And what was the core legal issue that made its way all the way up to the Court of Appeals? What was the precise legal question they had to answer?
The court had to tackle two very specific questions. First, is this sobriety clause a waivable condition precedent, or is it something more fundamental? And second, did Clark's lawsuit actually state facts that would count as a valid and effective express waiver of that condition?
Okay, so West, the publisher, their argument was that the sobriety clause was the actual consideration for that extra $4. They were basically saying we weren't just paying for a book, we were paying extra for a sober author. If they're right, Clark loses unless there's a new contract. So what rule of law did the court use to figure this out? Can you state the full rule and break it down for us?
Absolutely. The court created a really critical test. It says, a stipulation is a waivable condition precedent and not the non-waivable consideration, if that stipulation is just an incident to the method of performance.
Okay.
And if breaking it is intended to work a forfeiture of the price that was already agreed upon.
That's a dense legal sentence. Before we get into the elements, what's the big idea here? I mean, why is the court trying so hard to frame this as just a condition?
It's all about fairness.
Yeah.
The court has this deep-seated policy against what it calls unjust penalties. Look at it. Clark wrote a good book. West accepted it and is making money off it. For West to then turn around and slash 2/3 of his pay over a side rule, that looks a lot like a penalty or forfeiture. The court uses this rule to separate the main bargain from the minor details, to make sure the main goal of the contract is met without an unfair punishment.
That makes a lot more sense. So the rule has two main parts, two elements the court has to test. What are they again?
First, they have to figure out if the rule is just an incident to the method of performance instead of the main subject. And second, they have to see if breaking that rule leads to a severe forfeiture.
Thank you. Let's get to the court's elemental analysis. Let's go step by step. How did the court apply that first element? Was the sobriety clause the main thing West was buying?
So here's the first mini IRS. The court said the main thing being bought and sold, the subject matter, was the writing of the law book. The $6 per page price tag itself suggests that's what the work was worth. The court saw the sobriety clause as just one of many details about how the work should be performed, like, deadlines or formatting. It was a tool to get a good book, not the purpose of the contract itself. So, conclusion on element one, abstinence was just an incident to the method of performance.
Got it. The contract was for a book, not for sobriety. The sobriety was just a quality control measure.
Okay.
Okay, now for the second part, the policy side of it. What about the second element, the forfeiture question?
This analysis is pretty straightforward. The full price for the finished work was $6 a page. But $4 of that, a huge chunk, was tied to the sobriety condition. So if Clark failed, he lost two-thirds of his pay for a book that West had already accepted and was selling. The court said, yes, this absolutely meets the test. The clause was designed to work a massive forfeiture of compensation for value West had already received.
So, because it was just an incident to performance and it caused a forfeiture, the court concluded the sobriety clause was a waivable condition precedent. It wasn't the consideration.
Exactly. And that answers the first big question. It cleared the way. The condition could be waived.
Which brings us to the second question. Did Clark actually manage to allege a valid waiver? Let's start with the definition. What is the precise definition of waiver that the court uses, and how is it different from a similar idea, estoppel?
The court gives a very clear definition. A waiver is the intentional relinquishment of a known right. It has to be voluntary, and this is the most important part, it requires no new consideration to be valid.
No new consideration.
None. And that's what separates it from estoppel, which does require that the other party relied on the waiver and was harmed by it. Waiver is simpler. It's just one party choosing to not enforce a right, usually, as the court says, to relieve against forfeiture.
That distinction, no new consideration, that's the key takeaway for you listening. So Clark had to claim there was an express waiver. Just West accepting the book wasn't enough since they had to pay him the base $2 anyway. What facts did he allege that met the test for an express waiver?
Okay, so the test has two elements, knowledge and intent. Element 1, knowledge, was easy. The complaint said West had full knowledge that Clark wasn't abstaining long before he even finished the book. They knew.
Okay, they knew. But what about element 2, the intentional relinquishment? That requires some kind of action. West accepting the book as passive. What did Clark claim West actually did to show they were giving up this right?
This is the absolute heart of it. The complaint alleged that West didn't just accept the manuscript. It says West, and this is the court's language, repeatedly avowed and represented to Clark that he was entitled to and would get the full $6 royalty.
Wait a second. So just saying, don't worry, you'll get paid, is enough to waive a right worth, what, tens or hundreds of thousands of dollars? That seems like a really low bar for giving up such a valuable contract term.
It does seem low, but that's precisely the point, and it gets to the policy. The law sets a low bar for waiving a condition like this because the whole point of waiver here is to stop a massive, unfair forfeiture. West's repeated positive statements show they were intentionally abandoning their right to enforce the condition. The court is saying that the mutual understanding that he'd get full pay is enough to satisfy the test for express waiver. The goal isn't to punish West, it's to uphold the main bargain.
Okay, so after looking at all of that, what was the court's final conclusion?
The court held that Clark's allegations were enough to establish an express waiver. West had waived the condition, so they couldn't now insist on the forfeiture. But, and this is a really important nuance, the court made it clear that while the waiver kills the forfeiture, West still had the right to counterclaim for any actual damages they suffered because of Clark's drinking.
That's a very elegant solution. Let's try to lock this in with a hypothetical. Let's say I hire a painter to paint my house for $10,000. The contract has a condition. He must use a fancy Italian paint brand called Perfection Finish. Halfway through, I see him using a cheaper but still good American brand. I walk over and say, you know what, just finish the job, I'll still pay you the full 10 grand.
Okay, applying the Clark v. West rule. The core consideration is painting the house for 10 grand. The specific paint brand, Perfection Finish, that's a condition. It's an incident to the method of performance. If he finished and you tried to dock his pay by half, that would work a forfeiture.
So when I told him to finish and that I'd pay him in full, that was my express waiver.
That's it, precisely. And that waiver is valid, even without a new contract or new money, because its function is just to prevent the forfeiture on the main deal. Now, if the painter hadn't even started and you tried to waive the painting itself, well, that's the consideration. You'd need a whole new contract for that.
The distinction is clear. Waiver prevents forfeiture on the agreed price. It doesn't change the core deal. So let's tie this all together. For someone listening, if they run into a contract problem with a broken rule, how should they structure their thinking using the Clark v. West logic?
We can boil it all down into an actionable 5-step checklist, a roadmap for analysis.
Okay, walk us through it.
Step 1, identify the broken clause. First, figure out what you're looking at. Is it a promise where a breach just leads to damages? Or is it a condition where a breach leads to a forfeiture? If it's a condition, you move on.
Step 2, Condition analysis, the Clark test. Okay, if it's a condition, now you apply that key distinction. Is it the core consideration of the deal, or is it just an incident to the method of performance? And the lens to use is forfeiture. Ask yourself, was this clause meant to cause a loss of payment for work already done? If yes, it's a waivable condition.
Step 3. Analyze the waiver type. If it's waivable, look at how the forgiveness happened. Are we talking about an express waiver, which is an intentional act that needs no consideration? Or is it estoppel, which needs reliance and harm? We're focused here on express waiver.
Step 4. Apply the express waiver elements. For express waiver, you need to check for two things. A, did the waiving party have full knowledge of the breach? And B, was there an intentional relinquishment shown by some kind of positive action or statement? Remember, just passively accepting the work often isn't enough. You need that avowal.
And that leads to step 5, conclusion. If you've met all the elements, then the condition is waived, the forfeiture is gone, and the party has to pay the full price. But, and this is the final crucial piece, they can still turn around and counterclaim for any actual provable damages caused by the breach of that waived condition.
That roadmap is incredibly clear. So the big takeaway here is that waiver is a powerful tool courts use to stop unfair outcomes, especially when a broken rule is about the how of the contract, not the what.
Exactly. And that point about damages is so important. West lost the right to enforce that huge penalty. But let's say Clark's drinking caused a 6-month delay, or the manuscript was so messy they had to spend $20,000 on extra editors. West could absolutely sue for those specific tangible losses.
Which leaves us with a final provocative thought for you to chew on. Clark got his $6 a page. But what kind of quantifiable damage could West really prove was caused by a legal scholar having a few drinks while writing a treatise on corporations? The law protects against unfair penalties, but it demands real proof for actual loss. It's the ultimate balancing act.
And if you can master that distinction between a waivable condition and the non-waivable consideration, you've really unlocked one of the most vital concepts in all of contract law.
That's all the time we have for this deep dive. We'll see you next time.